Few topics in Utah family law generate more controversy than whether equal physical custody should be the presumptive starting point in custody disputes, and critics usually raise two objections. First, that there is nothing inherently magical about a perfectly equal split of parenting time, and second, that custody decisions are too sensitive to be influenced by any default at all. The first objection is obvious and uncontroversial, but the second collapses under scrutiny because the real question is not whether equal parenting time is ideal in every case, but whether the law should begin from a neutral baseline that treats fit parents as equally capable and then depart from that baseline only when evidence justifies it. That is what a rebuttable presumption does. Without an articulated default, custody decisions do not become more individualized, they become less transparent because unspoken assumptions replace articulated reasoning and unequal outcomes harden without justification. Saying that every family is unique misunderstands what presumptions do. A rebuttable presumption does not dictate outcomes, it allocates the burden of explanation, requiring inequality to be justified rather than assumed. Courts operate under time pressure, incomplete information, and human bias, and when the law supplies no starting point, decisions are shaped by habit, culture, and heuristics, not neutrality. High-conflict parents will litigate under any framework, but a clear presumption reduces unnecessary escalation in ordinary cases by narrowing the range of plausible arguments and discouraging narrative inflation. There is nothing sacred about 50-50 custody, but anchors matter, and beginning from equality respects the reality that children have two parents, not a primary parent and an auxiliary one. A rebuttable presumption aligns children's welfare with parental rights, preserves meaningful involvement by both fit parents, and demands accountability when unequal outcomes are imposed. Equal parenting time should not be guaranteed, but it should be presumed, rebuttable, and displaced only by evidence. When the law refuses to choose a starting point, it still chooses, just without explanation, and that is not neutrality, it is abdication.